Well, good evening. I can see that we've got participants joining us during these initial introductions. So let me introduce myself. I'm Francesca Levett. I'm head of pupillage at 5 St Andrews Hill, and I'm delighted that you're able to join us this evening. I'm joined tonight by Maria Scotland, our Deputy Head of Chambers, also joined by a number of our newest tenants and former pupils. So we have George Smart, Georgina Lane, Minahil Tariq, and also a tenant of ours, Guy Micklewright, and also Hannah Steventon, who is also one of our newest recruits, having recently completed a third six pupillage with us. So, let me talk to you about what we're intending to discuss tonight. So, I'm going to be talking to you about the criminal pupillage, just some basic information about it, because George and Georgina and Hannah will be offering more insight in relation to that. I'll also be talking to you about the application form and what we expect to see on your application form. So, really, some top tips to try and help you get the best out of your application process. In addition to that, I'll be talking to you about the interview process as well, so giving you some insight into how we conduct our interviews. Maria Scotland will be talking to you about the family pupillage and also about the financial award and how to apply in relation to both the family and criminal pupillages. Guy Micklewright will be giving you some insight in relation to professional discipline, as there are a number of different topics that we cover this evening, detailing the specialisms that we have in chambers. So, although we are offering criminal and family pupillages, there are other disciplines that you can also gain some insight into. So I've probably missed out a few bits and pieces, but we'll crack on and go straight into the criminal pupillage. So, as you may have seen, all the information is on our website under the pupillage section. But in relation to the criminal pupillage, we are offering two to start in October of 2027. And Maria will be talking more about the application process and the timetables that are available. But that's what we're offering this year in relation to crime. So if I can just briefly introduce you to Maria Scotland, she will talk to you about what the family team are offering this year and also the financial award and how to apply. Thank you, Maria.
Thank you. So there's a family team at 5 St Andrews Hill. We've got 13 members of chambers who practice in family law, and this is the fourth year in which we're offering a pupillage. Minahil is our last pupil to have gone through the process and to have gained a tenancy in October of this year. The family team covers a broad area of work, which includes finances, private children work, public children work, international family law, and court protection. And we currently have a pupil. For the next year, we're going to be interviewing, and there are two family pupillage awards which we're offering. One is to start in October 2026, and then one is to start in October 2027. So we'll be looking to offer both those pupillage awards in the same intake, and applications can be made through the Pupillage Gateway. The family pupillage will be broken down into 3 4-month periods. So you'll be shadowing 3 separate pupil mistresses. At the moment, we've only got pupil supervisors who are female. We haven't got any male pupil supervisors at the moment. So we've got 3 female pupil supervisors, and you'll spend from October for 4 months, likely with myself, if not with Sarah Wood. Then you'll go on to your next pupil supervisor, who'll either be Sarah Wood if you hadn't spent time with her, or you'll come to me. And then in your last 4-month period, when you'll be on your feet, and you'll have been on your feet for 2 months, you'll be with somebody else in the pupillage team. And what you will see whilst you're in your pupillage, we make sure that you spend time with various members of the team, following them around, so you get a wide exposure to all the areas of law that we cover, so finances, children, international law, and court of protection, in line with what your interests are. So you'll spend time with people in court, getting to know them, and also the areas of law. And towards the latter end of your second seat, if you like, you'll spend some time doing more paperwork and drafting, getting you ready for when you're on your feet and you're doing your own cases. And then in your second six, you'll be on your feet. And Minahil can attest to the fact that there's quite a good broad range of work available at the junior end for our pupils who are starting on their feet, which will cover work in both the magistrates' court and also in the family court. Probably not higher. So the Pupillage Award has increased this year, or will be increasing for next year, to 45,000, which is made up of a grant of 25,000 in the first six and guaranteed income of 20,000 in your second six when you're on your feet. But we do expect, what we've seen from our last three pupils, is that their income is much greater and exceeds the £20,000 guaranteed amount of income. And so that covers the what you'll be doing in very, very short form. If you want any further detail, then please pop down, a question down into the question box, or else feel free to reach out to us. The way in which the pupillage is conducted is you make the application through the gateway, and we keep in line with the Pupillage Gateway timetable. But as I said, in our next pupillage interviews, next round, we'll be looking to make an offer to two pupils. And so we'll ask you at the intake stage which year you're interested in. And so you can elect either the 2026 October intake or 2027, or else show preference for both. What we found in our past experiences, a lot of people are already working and have completed their training stage, and so they're ready to take a pupillage at the earliest opportunity that they're offered. So that covers the family pupillage.
Thank you very much indeed, Maria. Well, in relation to the criminal pupillage, the predominant areas of work are, of course, in crime, but you get the opportunity of seeing Proceeds of Crime Act proceedings as well. There are private prosecutions that are dealt with, and also when it comes on to Guy's discussion, he will be talking to you about the professional discipline side of things as well. But similar to what Maria said, the pupillage is divided into 3 lots of 4 months. There are a range of pupil supervisors, both male and female, and each of those will have a number of disciplines, but will dominate in crime. But if there is something you're particularly interested in, then of course you can put that on your form and ask us, if you're successful in getting pupillage, as to whether or not you can have the opportunity of experiencing some areas that you might otherwise not be familiar with. So let me talk to you now about the application process itself, and also what to put on your application form. Now, if any of you have applied for pupillage in the past, you'll be familiar with the gateway system that we adhere to. So there's a set timetable in that the applications themselves can be accessed from the 5th of January of next year. So you can't start writing your application, certainly on the system, until the 5th of January. However, if you've got access to the forms, then you can always start drafting up your answers and doing your research into various chambers at this early stage. But 5th of January at 11 o'clock is when it formally opens. Your application needs to be lodged no later than 11:59 p.m. on the 22nd of January. And then we can start reviewing the applications from the 23rd of January. And at 5 St Andrews Hill, we have a team of tenants that assist in this process, because it is a fairly lengthy one. But there are a number of forms. I think we had nearly 400 last year, where they are distributed to the tenants and then reviewed by a single tenant within a certain period of time. And then a second tenant will review the forms, or certainly a selection of them, in order to ensure that there is parity amongst the members of chambers when they're assessing the forms and giving their feedback in relation to them. Because it is quite a lengthy process, obviously we don't interview until March or April. So it gives us sufficient time to go through each of the forms to check our review and work out how many candidates we're interviewing. Last year we interviewed about 72 candidates for the 2 criminal positions that we had. So a fairly good proportion of interviews. So just under a quarter, maybe about a fifth of applicants got a first round interview. First round interview is then conducted over the course of a day between 3 panels, and then a second round interview takes place normally a couple of weeks after that, and that's normally with a group of about 5 of us that conduct the interviews. And there will be advocacy exercises involved in relation to those, but I'll talk to you about those in a bit more detail in due course. The offers that we make can only be made on the 8th of May, so we can't let you know whether or not you've been successful until the 8th of May, unless you have not succeeded in getting a second interview, in which case you'll be told after your application or your first round interview whether you've been successful. So the all-important thing is the form. It's your opportunity to really sell yourself and to give us a good insight into not just what you've done and what you've achieved, but also in relation to your personality, because personality is really so important. We don't expect everybody to be the same. One of the lovely things about Chambers is that it's full of very different characters who all bring their own special something to Chambers. And so we don't expect everybody to conform, to be a particular automaton. We love personality, and we want your personality to shine through on the form. Certainly those candidates that have made it through to our first rounds on previous occasions have got that certain something that really is promoted extremely well in the way in which they articulate themselves in writing, which of course is a key thing when it comes to being a barrister, getting those skeleton arguments out and making sure that you're persuasive before you even open your mouth is one of the essential things that you'll need to learn. Our forms are anonymised, so we won't know whether you're male, you're female, whether you're a mature candidate, whether you are in your first year at university and you're just getting ahead of things. We won't know anything about you. We won't know about where you've been to university or where you're intending to go. We won't know really anything about your personality unless you put it down into your form. So it's just so you know that there is anonymity throughout the form. So it's just your answers that we're interested in. There is an opportunity for you to identify your legal work experience. Now, of course, we recognise that not everyone will have done paralegaling, not everyone will have undertaken any form of internship, but what we would expect is that you have at least some insight, some work experience into the bar. So it may be that you've done a number of weeks of work experience in a solicitor's office, and that may well have been instrumental in telling you that you didn't want to be a solicitor. But in addition to that, we would expect to see at least one mini pupillage so that you've got an insight into how barristers' chambers work, how an individual works, bearing in mind we're all self-employed. Now, there will be a number of candidates, I was certainly one of them, that didn't have a huge amount of work experience because, quite frankly, I had to work all the way through my college and my university and every summer holiday because I needed to make up the money that was sorely lacking in the grants and things like that. I could still bring relevant work experience to my form, even though I didn't have a huge amount of legal work experience. But I don't want you to think that just because you haven't got 15 mini pupillages or a 3-week stint as an intern in the International Criminal Court, that somehow you're going to be off our radar. We fully respect the fact that people do have to work through university and they do have to work through their college. Some of you may have caring responsibilities. That means that you can't simply work for free doing a mini pupillage. So we take that into account. What it does, of course, demonstrate is that you have a commitment to your profession and you're used to juggling things and probably burning the candle at both ends. So there's a way in which you can promote yourself, even if you haven't got, as I say, 15 mini pupillages. But if you have done non-legal work experience in addition to at least one mini pupillage, then tell us about it. It doesn't have to be chapter and verse, but tell us what transferable skills you've managed to acquire during the course of your non-legal work experience as well. Don't be shy about putting that forward. There will be some individual questions on the form from us. Then they're unique to our chambers. They won't be on every single other form. So it will mean that you'll have to do some research in relation to us and also do some individual thought in relation to your answers. I would say to you, do your research. There's plenty about us on the website. There's also plenty of about us in things like the Legal 500 and Chambers and Partners, where you can learn a little bit more about us. But impress us with your research skills at this stage. Tell us why it is that you want to be part of our team. Tell us what makes us your top set of choice, because that's the sort of thing that will impress us to demonstrate that you know what you're joining us for. I would say absolutely read through your form, if not once, maybe twice, maybe get a third party to have a look through it, because you will be blind to certain spelling errors or various errors. So get someone else to check it, because it really does let you down if you put in your application form something that you've copied and pasted from a previous form. So just a bit of a tip there. I would also say that there is an extract of the form that talks about extenuating circumstances. I would say if you have extenuating circumstances, for instance, significant care and responsibilities, if you've suffered bereavement, ill health, anything that helps us understand why it is that your grades might not be quite where you'd wanted them to be or quite what you expected, let us know about it. I would simply impress, and I don't mean this harshly, but make sure that it is a proper extenuating circumstance. I think we had one candidate that said that he liked the beer too much or something like that. That's not really an extenuating circumstance that I would encourage you to put down on the form, but something genuine that helps us to understand why it is that maybe you didn't quite make those grades. Feel free to put it down. All right, so I think that's all I can say in relation to the application form. I should have said at the outset, if you've got questions, write them in the chat and we'll get to them at the end. But let me talk to you very briefly then about the interview process itself. As I say, we have a number of first round and then second round interviews as well. For the first round, we fully accept that not everybody will have been to bar school. Some of you will already be at university, maybe getting your applications in well in advance. So you might think, I've not had my advocacy training. How on earth am I going to impress in relation to some advocacy? Well, rest assured, in the first interview, it's not going to be any form of legal advocacy as such, but it is going to be something that we want you to talk to us about. So normally we have a discussion piece where you're asked to argue either for or against a particular point. It's a timed exercise and we'll stop you if you go beyond 3 minutes. Sometimes there are questions and interjections, sometimes they're not. But it's important, of course, that you arrive in good time to be able to review your discussion piece, undertake whatever research you might want to do very briefly with the assistance of your laptops or tablets. And then you can give your arguments to us. And then there's a short period of time where we get to know you a little bit better once the advocacy exercise has passed. I should again impress upon you, bring in your personality. Not all advocates are made the same. One of the loveliest things, particularly in both family and in crime, the nature of our work is we're in court fairly regularly, and it's lovely to go to court and see so many different types of personality in the advocates. So don't be afraid to be you and to shine through. If you get round to the second round interview, that will be an advocacy exercise. Again, not completely steeped in law. We're not expecting any form of legal application that you'd see in mooting or that sort of thing. But it will be either a sentencing mitigation or it will be a bail application or something along those lines. So if you haven't done so already and you have no advocacy experience, I would recommend getting in touch with the Inns, seeing if you can do some advocacy training or observe certain things, even just going down to the Magistrates Court or the Crown Court to see how a plea of mitigation is done if you've not managed to undertake a mini pupillage at this stage. The second round interviews are a bit longer, as you'd expect, but after the advocacy exercise, there's again some more questions. One thing I should raise with you is I'm afraid we don't offer feedback in relation to either the application forms or the first round interviews. We do offer feedback in relation to the second round interviews, and very often we give that at the time of the second round interview, unless we're pushed for time, in which case we're happy to follow that up in writing. And just to explain, the reason why we don't routinely give feedback in relation to the forms is, as I'm sure you can imagine, all of the work that we do as the Pupillage Committee is voluntary. It's on top of our workload. And when you're dealing with potentially 400 applicants, to be able to provide feedback from not one, but potentially two members of chambers in relation to that can be quite a time-consuming exercise. So I'm sorry that we don't offer feedback, but as I say, we do for the second rounds. Okay, I'm going to hand over now to George Smart, who's going to talk to you about his experience in criminal pupillage. And he's just been made a tenant with us, having recently successfully achieved it. So thank you, George, over to you.
Thank you, Francesca. Good evening, everyone. Yes, I'm going to talk to you about first six, so your non-practicing period of pupillage. As Francesca set out, your pupillage 12 months, you get 3 supervisors, so 3 4-month blocks. For me, my first supervisor practiced exclusively in crime, and my second, who sort of straddles your first and second six, she practiced exclusively in extradition. So it's a non-practicing period, and what that means is your time in first six is spent with your supervisor when they are in court, assisting them with whatever it is they are doing on their cases. So practically, your supervisors are sharing with you case papers that they're working on. You're expected to read through those and form a view on things like the offences that are the charges that a defendant may have been charged with, points of law, evidence in a case, and you'll be discussing those with your supervisor. They're very interested in what your view is. There's a big focus on learning as you go. And the way that that's done in first six is really through discussing those things with your supervisor. You're there for things like conferences with clients, so you get to see that sort of client handling aspect of the profession as well and how that works. And conversations between co-counsel as well, which is really interesting and wasn't something that really I've been exposed to prior to starting my first six. Inevitably, in criminal proceedings, applications are made. And when those applications are made, something will need to be drafted. So something that you'll also be doing in your first six is when your supervisor is asked to draft something in respect of one of their cases, you might be asked to have a go at that yourself. And then your supervisor will do a version, you'll compare them and you'll get feedback on that as well. And sometimes the work that you do, it can make its way through into a case, which is quite exciting. Other things you might be expected to do might be to plan questions for witnesses. So to have a think about how you would approach asking someone questions in a particular case that your supervisor is working on. And again, you would be able to discuss that with your supervisor. They would tell you how they would do it, and you would learn tactically how might be best to approach that particular situation. I think my takeaway from it really is that it is a really interesting and enjoyable period because it's, well, hopefully the last time that you're able to actually sort of sit and watch people doing advocacy before you're then, put in and you're doing it yourself. So it's a really fun 6 months. The other point I think to mention is that if something comes up from other members of chambers in your first six, so if there's someone doing a particularly interesting trial, you might be asked to go and accompany them for that. So in my first six, I was asked to join one of our silks who was defending in a murder trial for a month. And he mentioned that to my supervisor and said, would George want to come along on this? I think it's going to be really interesting. And my supervisor said, yeah, go for it. So I went and did that for 4 weeks. So there's a real focus on making sure that you're seeing interesting work and you're learning from members of chambers. I'll quickly touch on the social aspect as well. So Chambers is really good at organising social stuff. Once a month, everyone gets together at Chambers for some drinks and just to sort of catch up. As you can imagine, everyone's out doing their own thing, usually in the day and in the week. So as a first six pupil, you'll probably be attending those and you'll get to meet other members of Chambers at those. You'll be told about various talks and events that are held at Chambers usually for other areas of practice like extradition and Proceeds of Crime Act related stuff. But there's a lot of events that happen at Chambers that you have the option of joining. And the clerks will encourage you to join networking events with solicitors and other legal organisations, which you'll be told about and you can participate in. The last thing I will say is that in your first six, you get exposed to, obviously, to criminal work. That's what you're there for, but other areas of practice as well. And your first six is a really good opportunity to do that because it's before you're actually on your feet doing your own cases. So in my first 6, I was asked to do bits of work for other members of chambers covering things like government advices, immigration advices, bits of work on extradition, proceeds of crime work, and professional discipline and regulatory work. And that can be things like researching or drafting or whatever. If another member of chambers has something interesting that they're working on, and they think it might be useful for a first 6 pupil, it will usually be shared your way, and you'll be asked if you've got capacity to look at it. I will briefly touch on the advocacy course because I know Georgie's going to cover that in a bit more detail, but throughout the whole of the 12 months, you're also taking part in a sort of a training program that chambers run, where members of chambers on a monthly basis set you a task, an advocacy task, you work on it, you then come in once a month and you perform it, and you get feedback, and you do that with your co-pupils. But I'll let Georgie talk to that in a bit more detail. That's everything that I had to say about first 6. I'm sure if anyone's got any questions, pop them in the chat and I'll have a look at them.
Thank you ever so much, George. As you have foreseen, we're going to go over to Georgina now, who's going to talk about second 6 pupillage in crime. Thanks, Georgina.
Thanks, Francesca. So yeah, once you move into second 6, you'll be in court daily, both in the magistrates court and the Crown Court, and there's like a good mix of work between both. That includes lots of trials in the magistrates court, as well as like PTPHs, sentences in the Crown Court, and you also have the opportunity to do Crown Court trials when you're ready. You also, or I at least, have covered some proceeds of crime hearings and also extradition mention hearings, as there's lots of those going around. So again, you sort of get some exposure to that during second 6. Throughout second 6, you continue to have regular contact with your supervisor. I called my current supervisor, or one of my 2 previous supervisors, possibly on an almost daily basis, to ask them any questions that came up whilst I was at court. There are also various WhatsApp groups, including one with all of the most or more sort of junior members of chambers, which again is an easy place to just pop any questions you have, if you have any that arise during the court day. And you're also assigned a wellness buddy throughout pupillage, not just in second 6, but right from the start. So you have sort of a specific point of contact if you need any extra support or just have anything that you want to discuss. So definitely throughout pupillage, but in particular during second 6, when you sort of need it most, you really do have a huge amount of support available to you through both other junior members of chambers, but also your current and previous supervisors. George just touched on the advocacy training. So during first 6, the advocacy training is primarily focused on criminal law. You do bail applications, plea mitigation, examination in chief, cross-examination, closing speeches, and they're all based on real cases, which gives you sort of a really good sort of go at doing that in that environment, rather than having, potentially moves you on a bit from sort of the bar course advocacy. And that all sets you up really well for being in court in second 6. And then during your second 6, you continue to do advocacy sessions, but they are more focused on other practice areas. So we did one on extradition, we did one on proceeds of crime, and we did one on professional discipline. And again, I actually found those almost the most useful in giving you an opportunity to have a go at those types of hearings without having necessarily, you are primarily doing criminal law work in the magistrates court. So it's a good opportunity to sort of have a go at those other practice areas. And then finally, as George mentioned, in terms of doing written work for other members of chambers, you continue to do that in second 6, perhaps slightly less. Obviously, you've got quite a busy practice yourself. Similar to George as well, a lot of the written work I did for other members of chambers related to other practice areas. So my final supervisor specialised almost entirely in proceeds of crime. So I did quite a few skeleton arguments, drafted skeleton arguments for final hearings and proceeds of crime, which again was quite a good way to sort of get some exposure in relation to that area of crime specifically. That's sort of a whistle-stop tour of Second Six. Obviously, if you have any specific questions about it, either put them into the chat or feel free to reach out. But for now, I think I'm going to pass over. Am I
Thank
passing
you.
over to Hannah or Minahil?
In fact, Georgina, a question that's come up in relation to Second Six was how early does one find themselves in the Crown Court during their Second Six? Do you have any insight in relation to that?
Yeah, so I mean, in terms of sort of just being in the Crown Court very early, sort of doing PTPHs and sentences and hearings like that, I think I probably was in the Crown Court my first week. In terms of doing Crown Court trials, that can come a bit later on. George, I believe, had his first Crown Court trial sort of maybe 4, 5 months in. So it's also sort of when you feel ready, obviously, to do one yourself.
And how often would you say that you're in the Crown Court in the 6 months that you have for Second Six?
Very regularly. I mean, almost daily basis, I would say. It's sort of pretty much an even split between Magistrates Court and Crown Court.
Brilliant. Thanks, Georgina. We're going to pass over now to Minahil, who's going to give some insight in relation to the family pupillage. Thanks, Minahil.
Thank you, Francesca. So I was the family pupil in Chambers last year. Obviously, my experience was similar to George and Georgie's in first and second six, but some slight differences, I think, for the only family pupil in Chambers. So first of all, in your first six, I spent a lot of time with Maria, who was my supervisor, sort of building a diary almost. So it wasn't just shadowing my supervisor and doing work for them, but also trying to figure out the different areas of family law that I wanted to cover and see areas that I had prior experience of working as a paralegal and those that I'd never seen before and I wanted to learn about. And that was really interesting because I was able to add more of the things that I liked or had less exposure to. That would mean shadowing Maria, but also shadowing very quickly many other people in Chambers. The family team is smaller than the criminal team, so it's quite nice to be able to get around and meet everyone in the team quite early on in pupillage to see all the different areas that everyone has and how they run their own practices. During my first six, I was in court pretty much every day, I think. So days where I wasn't shadowing Maria, I was shadowing a different member of Chambers. If it was a short hearing, that meant I was in Chambers in the afternoon working on papers or doing some drafting. And that can include doing position statements, orders, doing some legal research for people in Chambers. In my first six as well, there's a transition then to a second supervisor. So I had Gemma Linfield, who was my supervisor after the new year. And again, with Gemma, I saw a different variety of work to Maria's. I saw a lot of international work as well with her. And that was a really good way to sort of cover a really unique area of law that you don't always get to see a lot of in pupillage. In your second six, transition-wise, you are in court slightly less than the criminal pupils, so it's a slightly slower transition. You build up with about 3 days a week in court, but around sort of summertime, you'll be in the full swing of it, and you're likely to be in court every single day. I have over the summer been in courts just back to back. It can be really busy, but really fun as well. During my second six as well, you have a good mix of sort of interim hearings. You predominantly will be doing legally aided work, but there is a lot of opportunity to do privately paying work as well. You will start doing complex hearings almost from the get-go. So I did a fact-finding hearing about my second week into my second six. So it's a really good way to sort of get used to doing complex hearings as well, final hearings, fact-finding hearings. But alongside that, most of your everyday work will be short interim hearings, and you'll have the time to read papers, draft position statements, and court orders. That is sort of second six. You will have the opportunity, of course, to rely on the full family team. And I think depending on what area of law I was doing the next day, I was calling different people. So it doesn't always have to be your pupil supervisor, but it's really good to have the entire family team to rely on, not just juniors and chambers. Another sort of difference slightly with family pupillage is that you will get to shadow the juniors in chambers quite early on and throughout. So it's really good to be able to see the type of work that you will do in your second six, which can predominantly be a lot of injunctions, non-molestation orders, occupation orders, and a lot of private children work. So it's really good to start building up and understanding the type of work that will be your bread and butter once you're on your feet. In terms of advocacy exercises as a family pupil, you do the same advocacy program regardless of whether you're family or criminal. That means the criminal pupils had to do the family exercises and I had to do the criminal exercises. And that can be really challenging when you're not used to doing that area of law. But in a way, it was a really good opportunity to build up transferable skills, regardless of whether or not I'm doing those areas of law anymore. And it was really good to just understand and have a base learning in them. That is sort of a really quick rundown of the family experience during pupillage. And I think Hannah will talk a little bit more about the transition then from pupillage to tenancy.
Thank you ever so much, Minahil. Yes, so we're going to pass over now to Hannah Steventon, who joined us as a third six pupil and then gained tenancy after serving those 6 months. So Hannah, over to you.
Thank you very much, Francesca. I joined Chambers back in April as a third six pupil, predominantly wishing to expand my practice. And now I undertake not only criminal work, but also proceeds of crime, extradition, and looking to expand into professional regulatory. So that's one of the benefits of coming to Chambers with such a varied practice. I also undertook all the training that was done with the second sixes, and I've sort of worked in parallel with them, which was really beneficial to be able to also gain that experience and also have the support of a supervisor and the buddies that Georgie has already mentioned. One thing perhaps to mention as a third six is that there is also, depending on your arrangement, a guaranteed earnings package, which can be extremely helpful if you're still in the very junior end of your career. Having that as a support network, that's essential to have when you're coming into a new Chambers. They also undertake work for other members of Chambers as well. And as George has outlined, there's plenty of social events and other events outside of Chambers that you're encouraged to undertake throughout that time to really expand your support network. So when it comes to applying for tenancy, you're informed towards the end of your 6 months, whether that's as a second six or a third six, about the procedure. So for us, that involved sending over our CVs, cover letters, pieces of work we'd done within Chambers, and also some references. But throughout your second six and your third six, you will be encouraged to assist in that written work, and I believe also probably in third six. So by that point, you'll have probably already built up a portfolio of work that you can pick from. And additionally, the clerks can help you if you're concerned about reaching out to solicitors and help you support you through getting those references so that you're all ready to go by the time it comes to handing in your full application. Once you get tenancy, that is decided by a panel, but also I believe that all members of Chambers sort of have an input into that. So once the offer comes in, you can celebrate, but also that's a time when you can organise to have a practice meeting with the senior clerks and director of Chambers. That's a really important opportunity for you to outline where your future is going to go and how you want your practice to develop. If there's areas that you want to expand into, or perhaps areas that you've had the chance to look at and aren't particularly keen to continue in that area, that can be your chance to have your say and to tell the clerks which direction you want to go to. And I would describe the transition as extremely smooth, to be honest, because Chambers really builds you up to a point where you feel ready to go. I think that our main worry was getting tenancy and not the other side. And I think we've all had a very smooth transition in that way. And it's not like the support network suddenly disappears from beneath you. I think, as Georgie said, your supervisors are still there, the junior WhatsApp groups are still there, and there's still plenty of people that I lean on every single day throughout third six, but also now into tenancy, that have remained constant sources of support. So as I said, it's a very smooth transition because the one thing that changes is your title, but otherwise the support network's there throughout. So Chambers is very good at preparing you for that. As I said, I have a slightly different perspective because I joined Chambers as a third six. So if there's any questions that I can answer about second six / third six, then feel free to ask. And also any questions about going into tenancy and that change. I think I saw a couple of questions perhaps about work. I was very similar to the other two. I mean, I was in the Crown Court predominantly, and also throughout tenancy, you're also heading more into the Crown Court as well, but whilst having that balance between Crown Court and Magistrates Court work. So, thank you very much.
That's great, Hannah. Thank you very much. Whilst we're on the subject, and before we move on to Guy, there's been a question here as to how did you decide on the specific area of law you wanted to go into? So if I can ask you to address that, then if Georgina, George, or Minahil have any further insights into it, they can chip in.
Well, in terms of my interest in criminal law, I've always had an interest in that throughout university, well, throughout my secondary school career, really. Criminal law has always been an interesting aspect for me. It's very complex, it's very varied, every day is different. Specifically at the bar, as a criminal practitioner, you are in court every single day. And so if you have that passion for advocacy, that's definitely one of the correct areas to go into, because you will literally be in court every single day. You'll be on your feet every single day. And if you enjoy making those legal arguments and building complex skeletons, it's a perfect area to go into. I particularly enjoy how varied it can be. I mean, we truly are one day doing a driving matter and the next day doing a big drugs conspiracy case. So it's very, very varied, and I can say for certain it's never ever boring. The addition of extradition work, I always had an interest in international law, so that was an area that I was particularly interested in going to as well. But I think the opportunity, especially in second six and potentially first six, but of exploring those other areas is great. It's a safety net to sort of dip your toes in before you fully immerse yourself into building a practice in that area. And there might be areas that you thought that you were made for, and then you experience what it's like day to day, and it's not particularly for you, and vice versa. So making sure that you keep your options open is also very important.
Thank you, Hannah. All right, so I'm going to introduce you now to Guy Micklewright. Guy's a tenant in Chambers and specialises in professional discipline, and he's going to talk to you about that as one of the aspects of pupillage that can be covered. So Guy, over to you. Thank you.
Thank you very much, Francesca. Evening, everybody. Yes, I'm a tenant in Chambers. I'm a tenant who specialises in professional discipline. I joined Chambers in 2021, having spent the prior 14 years in private practice at a combination of solicitors firm and the General Dental Council, practicing in fitness to practice. And before then, I was originally a practitioner in crime at 2 Bedford Row. So I've had a slightly varied career in terms of finding my way back to the self-employed bar and to 5 St Andrews Hill. So what I'm going to talk to you about, I'm going to take you on a whistle-stop tour through the team, what the team does, and how our work can be done both by pupils and also, perhaps to a greater extent, by junior tenants, were you to come and join 5 St Andrews Hill and be taken on as a tenant. Now, the team itself is, compared to the size of the other teams within Chambers, comparatively small. The practitioners who specialise exclusively in professional discipline, there's only 5 of us at the moment who do professional discipline to the exclusion of all else, but quite a large number of other members of Chambers, however, have professional discipline in one way or another as part of their wider practice. So whilst, as I say, there's relatively few of us who are doing it absolutely exclusively day to day, there are quite a large number and increasing number of members of Chambers who are taking on this work. Now, in terms of the work we do, we as Chambers act for the majority of the healthcare regulators, and that includes the statutory healthcare regulators, but also the smaller non-statutory healthcare regulators, Social Work England and others. We also act for a number of the accountancy regulators, and we work with a number of the leading firms in this area. But in addition to that, we do a lot of defence work and an increasing amount of defence work before those self-same regulators, the legal regulators, the BSB, the SRA, accountancy regulators such as the ICAEW, and indeed others. We also have quite an extensive amount of work in what is a developing area, which is university misconduct. We have one supervisor in Chambers who specialises in professional discipline, and I anticipate that in the very near future there are going to be others who specialise in professional discipline who are going to be working as pupil supervisors within chambers. So there's going to become an increasing number of opportunities available for pupils to experience professional discipline during the course of pupillage, in addition to what George has already touched upon, which is the opportunity you would get in any event to be able to do work for a number of members of chambers relating to their specific practice area, as indeed George did for me during his first 6 pupillage, and a great job he did on a very complex piece of work he did too, if I may say. As a pupil, you'll get an opportunity to observe, do written work, as I say, in professional discipline matters, but you'll also get some specific training. There is training put on for the sort of hearings you might do, both as a pupil, but also particularly as a junior tenant, which may include applications for interim orders restricting practitioners' registration, what a short substantive hearing, a trial essentially, would look like, and potentially also an application in the High Court to extend an interim order, of which there are a surprising number amongst a number of the healthcare regulators. Where the opportunities perhaps increase are once you hit the stage of a junior tenant. And whilst this is obviously primarily a discussion about what it's like to be a pupil, inevitably as a pupil, you're going to have your eye firmly on what practice is going to look like when you become a tenant. And for chambers, professional discipline is starting to become, I think it's fair to say, a more and more buoyant area. It is an area of work generally where there is a lot of work to be won, and it's certainly an area which, in terms of the number of instructions coming into chambers, it's definitely increasing. So it's going from an area which, going back a few years, was quite a specialist niche area in chambers, to one where the work, the amount of it is growing, it's increasing in complexity, it's increasing in the amount of it and the number of instructions, and there's plenty of opportunities for those who are interested in doing it in starting to look at this area, and we would encourage you to do so if it's an area with which in which you're interested. There are secondment opportunities that come up. Examples of where we have had secondees include the HCPC and the NMC, 2 regulators you may well be familiar with. And certainly those who've spent time on secondment there have very much enjoyed the experience. They found it very rewarding. So as I said, that's a very brief whistle-stop tour of what we do within chambers and of the opportunities there are to work in professional discipline. And it's something which I would encourage you to look at. I'll be very happy, of course, to take any questions which you may have on it at the end. As has already been touched upon, of course, this is not the only area of specialism which chambers have beyond crime and family. Chambers is well recognised for its expertise, particularly in POCA and also in extradition, and has already been touched upon by others. Those are areas which you are highly likely to get the opportunity to work on as a criminal pupil as part of your pupillage. Thank you very much.
Brilliant. Thanks ever so much, Guy. Question that's come up in relation to professional discipline work is, does your work include police misconduct hearings and appeals?
We have, I think, 2 members of chambers who sit, I'll be corrected if I'm wrong, who sit on police misconduct tribunals. At the moment, there's only a very limited amount of police misconduct work being done as advocates in chambers. So the answer, in short, is at the moment, no, not very much. But it's an area that we have targeted to expand on in due course.
Brilliant, thank you. All right, so we have time now for a few questions. So what I'm going to do is go through some of the questions that haven't been answered yet and see if we can assist you in relation to that. So first question for the crime team, what is the geographical coverage of chambers? Is there a particular focus on certain areas, for example, Central London, Kent and Midlands? I can say that certainly for tenants, we go all over the place. We tend to be predominantly in London or the South East. That includes East Sussex, West Sussex and Kent. But also we have a growing practice in the Midlands, and we do go further afield as well. I don't know if any of the pupils have gone further afield and what has done in relation to paying for train fares and things like that, if you've had to go out of the area. Perhaps one of you would like to take that. Georgina, thank you.
Yeah, so I definitely did a few further afield with Birmingham, Southampton, Cheltenham, and either you are paid, so you pay for your train ticket yourself and then you'll pay back, but also it was made very clear by Chambers that if we had difficulties in paying for a train ticket like that up front when they're more expensive, that they could cover the cost of it sort of up front, and then they would obviously almost be paid back themselves, if that makes sense.
That's great.
That's a very good point, actually, in terms of not just the criminal pupils, but also the family pupils. You're not expected to pay for your travel outside of the London M25 out of your pupillage award, and Chambers will cover the cost of that. So that's whether you're on your that's whether you're following somebody and observing them or on your feet. We also do cover some costs for other training events and social events. And then you're not expected to cover that from your award.
Thank you, Maria. Maria, while I have you, there's a question about the advocacy exercise undertaken for the family interview, as to whether or not it would be a clear mitigation of criminal matter, but clearly that wasn't the case. Could you just tell us what the advocacy exercise entails, please?
Yes, good question. It was for the family team. In the past, we've had an ex parte application for a non-molestation order. So in plain English, an application for injunction where there's only one side. So you're pretending that you're appearing on an urgent basis before a judge and you haven't notified the other side, explaining why you haven't got the other side there. Yeah, you're given the papers, I think 45 minutes before, 30 minutes before, and then expected to make the application.
Brilliant, thank you. I should say in relation to that, from a timing point of view, we do have applicants who need additional time, and that's because they have something like ADHD or something along those lines, dyslexia. So if that's you, don't be afraid to ask for that. You'll be given extra time in relation to preparation for your discussion piece in the first round, as well as additional time for the advocacy exercise, and that's in both disciplines. Thank you. Now, perhaps a question for the pupils, former pupils, I should say. There's a question here: what sets 5 St Andrews Hill apart from other chambers in terms of a criminal pupillage? So I'm going to direct that to you in the first instance. Perhaps Hannah, if you want to answer that. Because obviously we can talk about it from a more established tenant's point of view, but you will have colleagues who've undertaken pupillage, and you will be able to compare and contrast why we are perhaps a bit different in relation to criminal pupillage.
I suppose from my experience and my experience talking to other pupils, I can say that it's a very supportive set. So from that sort of thing, as I think I've mentioned a lot of support within Chambers, but also the structure of having things like buddies and having the WhatsApp groups. That's something that I found very helpful within Chambers. And in terms of the workload, I would say we do quite a lot in the Crown Court quite early on into third six, second six. I can't speak on behalf of George and Georgie, but from what I understand, in their second six, they were in the Crown Court quite a lot. And so I think that's one thing that's quite that sets us apart slightly a bit more. But perhaps George and Georgie can go a bit further into second six in particular, or perhaps first six.
Yeah,
Thank you, Hannah.
I think what I would add to that is, like, my experience in speaking to other pupils is that Chambers is definitely very well regarded in other areas of practice, such as extradition, and obviously professional discipline and proceeds of crime, that as a second six pupil, unlike perhaps other sets, you are doing and picking up work in those areas as well. So it's quite common for me to be sent to Westminster to do a day of extradition, for example, which speaking to other pupils is perhaps less common from my experience in speaking to them across other criminal sets. So that diversity, I suppose, is something that I don't think is as common across other sets that you definitely get at 5 St Andrews Hill.
Thank you. All right, I've had a question here. For crime, what's the general split between legal aid and privately funded work that chambers are instructed on? I mean, to be fair, it varies from practitioner to practitioner, but I would say the vast majority of the work that we do is legally aided. So far as privately funded work that comes in, I don't know whether or not that's very commonplace in the Magistrates' Court and in the Crown Court for our junior tenants. But Georgina, have you had any privately paying work?
Yeah, I've had a private paying magistrates court trial, and then other than that, the majority of the private paying work is driving offences. So doing exceptional hardship applications where people have hit 12 points. So you get sort of some of that kind of work in terms of private work.
Yes. How about you, George? Have you had any privately paying work yet?
Yeah, similar to Georgina. I don't think I have had a privately paid trial recently, actually. So yeah, they do come in. It's difficult to give a percentage split, but the majority is legal aid at our stage. But yeah, there is every now and then I think something does come through.
Yeah, good stuff. Thank you. And there's a question here. How do we recommend that an applicant should translate common experiences like clinics or moots into insights that are specific to criminal law rather than generic advocacy lines? So in response to that, I would say that if you're assisting at a clinic, then you're going to be people facing. You're going to be dealing with individuals who most likely are in crisis and want to have some assistance from somebody that's objective and rational and can give them some reassurance as well as some well-meaning advice. So although you may be in a clinic dealing with a housing issue or something along those lines, then that still translates to how you're dealing with an individual. So it won't necessarily be advocacy as such, but people handling and people handling skills are absolutely essential in both criminal and family law work, because you are meeting people who are quite probably at their lowest point and they need some help. So if you are not particularly caring in relation to your client, either at a clinic or elsewhere, then you're going to have to think about how you're going to cope with somebody that is really struggling when they're in the cells at the Mags Court or going through frightening procedure and family proceedings where they're at risk of suddenly losing their child. So that's something that you can translate, I think. So far as moots are concerned, well, it's research. Certainly in relation to both criminal and the family law work that we do, you'll have to undertake research and be on your toes in relation to legal applications. You'll have to present skeleton arguments that are concise, well rehearsed, and put together so that a judge can immediately understand all the relevant issues, and then you can wow them with your advocacy afterwards. So mooting, whilst a lot of that is to do with very niche points that you're going to be arguing in the divisional court, it does translate certainly to how you'll be a better advocate when it comes to being on your toes for those unexpected legal applications. Submission at half time, for instance, is always something that has to be done fairly rapidly after assimilating all of the facts and the way in which the evidence has come out. So I hope that helps. Let's see, how are we doing for time? We're need to finish, I think, unfortunately, but let's see if there's one last question that we can deal with. Here we are. So what 3 words would you choose to describe 5 St Andrews Hill? That's a nice one. So Maria, how would you describe that in 3 words as our Deputy Head of Chambers?
Friendly, collegiate.
That's only 2. Come on.
That's only 2.
Yeah, absolutely.
Well respected. That's 4.
And I should also add to that, incredibly talented. I'm so bowled over by the talent that we get through our doors. certainly our pupils that are then made tenants. I'm incredibly proud of them, but every single person that is a member of Chambers at 5 St Andrews Hill is immensely talented. So there you go. I'm going to big us up, but that is the truth of it. Guy, how about you? How would you describe Chambers in 3 words?
Yes, I should have thought that through, shouldn't I? Just in case of being asked. But I thought I got away with it when you asked for it. I would say friendly again, supportive, and unstuffy would be the 3 I would choose. And I have, and I mean all of that very genuinely. I've been really impressed when I arrived coming to Chambers back to the bar after many years from being in 2 different types of environments to be welcomed in such a friendly way by everybody in Chambers, to find that the atmosphere was resoundingly unstuffy, but throughout all of it, of course, is an incredibly professional group of highly impressive people who I very much enjoy spending time with. So yes, those would be my 3 words.
Well, they're wonderful parting words. Thank you very much, Guy. I'm afraid, everybody, that's all we have time for. I know that we've answered a number of your questions. If there are still some burning questions that you have that you feel haven't been answered during the course of this webinar, then do drop us an email and we will respond to you. But thank you very much for attending. I wish you all the very best of luck with your applications, and I hope to see some of you, if not all of you, at the interview stage. So thank you very much. We'll now sign off. Thank you.